Into our big conversations right now this morning. I've been joined in studio by Bernard Kwesi Adu Kwafu Esquire. He's a pivot lawyer. I saw that on the flyer and I was a bit curious. He'll tell us a bit more about that shortly as well. Then there's Raymond Tamaklo, who's a member of the government communications team and the NDC, which is the ruling party. We'll also be joined in studio pretty shortly by Austin Bracco Powers, who's a private legal practitioner as well, who will join us in the studio for the conversation. But we're going to start off from Sedinam Tamaklo, and a bit more in terms of the details as we've got since the U.S. District Court okayed her extradition to the jurisdiction. We know that the court says it has jurisdiction to conduct extradition proceedings. The court had taken personal jurisdiction over Sedinam Tamaklo, and the extradition treaty between the U.S. and Ghana is in force. Of the many things which was considered was the fact that indeed she had been convicted to up to 10 years after she left the jurisdiction in 2021 in search of medical treatment in the United States. She didn't return to the jurisdiction. She was sentenced in absentia and has since not returned. A lot of the time, conversations around her is influenced by prevailing circumstances with the country's former finance minister, and questions have been asked whenever Ms. Ofori-Atta's matters came up as well for conversation. But for now, we know that she is bound to make a return to the jurisdiction as we speak, following that okay from the U.S. District Court. I'm going to bring in the guests right now, and I'll start off with Bernard Kwesi Adu Kwafu Esquire. And good morning to all of you to start off with right now.
Good morning.
Good morning.
I trust that the weekend has been kind to all of us.
It's been quite stressful, but we are on it.
Why is it stressful? Matters in relation to governance or personal?
Personal issues.
Okay. More often than not, this will be pivoted towards governance stress. You're a pivot lawyer.
Pivot Law is the name of my law firm, so I'm also a legal practitioner.
Okay, so Pivot Law is the name of the law firm.
Yes, but a member of the MPP communication team as well.
Absolutely, that's fair. Sedinam Tamaklo, I'm sure for you in the NPP it will be exciting news that the court has okayed her return to the jurisdiction.
Well, it's something we've been hoping for some time now. We have had laws and some relationship with the U.S. in terms of this. In fact, the whole extradition thing is something which we received from our colonial masters over there so many years ago. Even though there has been criticisms against the law, because even the UK that signed that treaty are themselves, they've excluded themselves from that treaty since the 1970s. However, we have enacted it into law as part of our extradition laws, and so it's always a part of it. Even surprisingly, this year, about a year ago, we've had 9 people being extradited into the U.S. And the saddest thing is that we have not had the same thing from the U.S. side. Not even one person has been extradited to Ghana from the U.S. to face any charges or punishment. However, that is what the law is, and so we choose to go with that.
That is what the law is, and we choose to go with that. But in terms of the outcome, it's been something that has been longed for a very long time. At some point in time, there was criticism as to the NPP for failing to have taken these steps to have a return to the jurisdiction. And in my preamble, I mentioned how this is closely tied more often than not to the former finance minister whenever conversations come in relation to him. Would you say this is good riddance? That yes, you couldn't do it, and you've criticized the NDC whenever they've brought up Ofori-Atta. They are seeking to walk that talk, and by extension, they will say you should walk the talk in urging on your former finance minister to also return to the jurisdiction.
I think that we should be careful not to mix the matters because they are two separate issues. Sedinam was tried here in Ghana. She was tried here and she was convicted. And it is based on this conviction that an extradition treaty, we relied on an extradition treaty to get her back into this country. But that of the former minister, yes, there has been charges which have been leveled against him, but those charges have not been tried and he's not been convicted. Moreover, the issue that he was dealing with was declined in terms of the government never took the steps to get him extradited here. What he was facing was more with immigration and customs issues, and not with issues where there had been a conviction and so he was expected to be extradited into the country. If you look at it, before the US even will take steps to extradite someone, they must first of all assume that jurisdiction. They must also look into it whether indeed a valid treaty exists between the two nations. They must also know whether the offense satisfies the dual nature of it. That is, it's an offense both in the US and also in Ghana. And so these are things that we have to go through before you can look at the extradition. But that of the former Minister of Finance isn't the same as this. So the two cannot be compared.
The two cannot be compared.
Yes.
Right. Let me bring in Tamaklu as well. Another Tamaklu. We're talking about Tamaklu. For you in the NDC, would you say job well done? She's yet to return to the jurisdiction, but the U.S. District Court has okayed her extradition to the jurisdiction to answer for the conviction and to serve 10 years in jail.
Okay, thank you very much. Good morning to you. Good morning to my colleague on the panel, and good morning to our cherished listeners and viewers. And so, for me, as a spokesperson for the government, and the government itself at large, is pleased by the news that a court has okayed the pursuit of Sedina Tamaklu to be extradited back to Ghana to come and face jail term. Indeed, in the run-up to the 2024 elections, one of the major planks of our campaign was to come and pursue accountability and transparency, and where government actors and government public officials, act contrary to the dictates of their office and of the Constitution, they shall be penalized according to law. And so we are pleased by that. I have also been listening to my colleague talking about the extradition treaty and all of that, how it has been inherited. I don't think that there is any issue in terms of the extradition arrangement between Ghana and the US, despite the fact that there's a treaty that has been inherited from colonial masters. The fact of the matter is that our Constitution, gives way for ratification of laws. And so, had the law been bad, I am sure Parliament is well endowed with the power and the authority to have invalidated the treaty. But because we thought that it is good law that we can practice, it has been ratified. And so there is no concern over that. Also, with the issue that has to do with the fact that the extradition over the period has been 1 week. The truth of the matter also is that in every extradition case, it is peculiar. The matters are not the same. They are distinct. And so at all times, the courts will look at the peculiar nature of the matter before it to make a determination as to whether or not an individual is to be extradited. And so in our case, today, Abu Trika is before the courts, and the court has said that there is a prima facie case that has been established against him, and that he has a case to answer in the US. He does not necessarily need to be prosecuted or announced or declared, as convicted or guilty for him to be extradited. So that point must also be made. So for me, I think that it is good news. And also, in the pursuit of Ken Ofori-Atta, the usual rebuttal from the MPP continues to be that, why are we pursuing Ken Ofori-Atta and not Sedina Tamaklu? The Attorney General has been persistent on the matter that they are pursuing also the issue of Sedina Tamaklu, and that in due course she will be extradited. And that is what has happened. And so you can see that this is a government that is committed to ensuring that accountability is exerted. Even though Senator Tamaklo served in the erstwhile NDC administration between the periods of 2013 and 2016, today she has been extradited. But I must also be quick to add that even though the court has declared that she should be extradited, it is not automatic. It is also subject to approval, executive or administrative approval. And so the Secretary of State must approve or state whether or not they agree that she must be extradited. Then also, secondly, she is entitled as an individual to appeals. And so she can make an appeal. And then there must be, there is also the opportunity for habeas corpus application, whether or not the authorities that have held her has the legal authority to, in fact, hold her as a prisoner. And so all of these processes would have to be gone through if she deems it fit that, okay, she wants to enter an appeal or a habeas corpus application, whether or not the U.S. administratively wants to extradite her. But to the pursuit of her extradition, what we can do as of yet to show that indeed we are after accountability, we have done. And the courts have said that she should be extradited. That point must be made. Also, Ken Ofori-Atta does not need to be prosecuted in absentia and declared as guilty before we pursue his extradition back to Ghana, where the court of the U.S. makes a determination that indeed, he has committed certain offenses, where they have made a determination that the pursuit of Ken Ofori-Atta is not politically inspired and that it is purely on matters of law and on the account of his service to the nation in his capacity at the time as finance minister. It is solely on these bases that the courts would make a pronouncement whether or not Ken Ofori-Atta should be extradited. And so, as to the question of whether or not there has already been a pronouncement in our Ghanaian courts, it is irrelevant entirely to the pursuit of Ken Ofori-Atta in the U.S. to be extradited back to Ghana. And so this is indicative of enough of our commitment, the political will to make sure that we pursue accountability. Because the Attorney General has the authority to say that, okay, they are no longer interested in the Senator Tamaklo issue. But it is not the case. We made a promise to the Ghanaian people, and there will be no cherry picking. If you have fallen short of the law, if you have not been accountable enough, if you have embezzled government resources, if you have misapplied public funds, if you have abused the public purse, then this government is going to make sure that you answer to the laws, whether or not you are a member of the NDC, you are a member of the NPP, PNC, or whatever political polarization you have as an individual. So long as you have served in government, so long as you have served in public office, so long as you have engaged in embezzlement and the abuse of our coffers and of our laws, we are going to make sure that these individuals are held to the feet of accountability. And when she comes back, there's been a pronouncement. She's been pronounced as guilty and convicted in absentia. But if she comes back and feels that the court has unjustly convicted her, she has the opportunity to appeal.
Are you not making, I mean, that's been said as making excuses, because we had the AG on the podium as well when this question was asked, suggests that there are a number of options available in terms of what the sentencing of the court has been in the jurisdiction here in Ghana. Yes, she's yet to return, but already there are those who say that as a party, you're preparing legal maneuvers for her to avoid jail term when she does return.
That is not the case. And what would be the reason, okay, that necessitates that narrative that we are going to create legal maneuvers for her not to be sentenced? A court of competent jurisdiction has pronounced her as guilty and has sentenced her to a 10-year jail time with hard labor. What maneuver? Not even the president can say, in a case where a person has been convicted by a court of competent jurisdiction, to not serve a term. But it is also within our legal, our laws and our legal frameworks that where an individual feels not as satisfied by the outcome of a judicial process or pronouncement in court, that individual has that legal right to go for an appeal. And so what would be the correlation between an individual's personal right to enter an appeal and any perception that the government wants to maneuver its ways? It is not the case. And at all times, we must stick to the substance and the facts of the issues.
Absolutely.
Yes, and so if she comes and she thinks that she wants to go into an appeal and that her prosecution in absentia was not fair enough to her, she is allowed within the legal framework. And we should not play political hide and seek with the matter.
Right, let me come back to you, Bernard. In terms of the outcome, as we've seen it from the court, obviously Raymond has mentioned possibilities as to things that can happen, even in the US, right? So the district court saying that it is okay or giving or granting approval that the basis upon which a request is being put in to have it extradited is good enough. There are still legal remedies to Sedinam Tamaklo to pursue in wanting to return to the jurisdiction. What's the position of the NPP in relation to all of this?
Absolutely, that is the law, and it's rather surprising that on one length, they speak about Ken Ofori-Atta, who also have gone through that due process. In fact, in the Ken Ofori-Atta's case, the court itself, the judge stated that it didn't have any documents for an extradition before it. This was as at February 19th. When the case was pronounced. They hadn't filed anything as such. And so based on that, the Ken Ofori-Atta's case was, set aside in terms of the extradition.
He was granted bail. The extradition has not been set aside. Yes. It's just been granted bail.
But there is no document as such before the court. There's no document of extradition before the court, which was stated by the judge in granting that bail. So the factors are different. And aside that, they have procedures, as my brother was saying. Those procedures have to be exhausted. But when we look at Sedinam Tamaklo's case, yes, the NDC is making the case for these procedures. But we see that there have been instances where we don't see the will from the government to prosecute people who are within its ranks. And there are so many cases that we can make assertion to, that even when this government came, some people who were facing trials in the courts have all been a nollie prosequa has been entered in for all of them, right, to be set aside. Even our current finance minister's issue is one of those things. So there is no will from the government. And so we can say that from their end, some of these things they are saying, yes, though that is the procedure of the law, but it's just excuses they are making up, because the will to prosecute their own is not there.
You don't think, on the finance minister bit, I think the AG was seeking to file an appeal of the no case by the Court of Appeal in relation to the matter, and this current Attorney General said he wasn't going to pursue that option. You are using that as a basis to say that there's no will?
No, that is just one. That is just one of many cases which have happened in the previous government. Whilst a number of people were facing issues within, with the courts, all those issues have been set aside. And the government is not willing to pursue. So if the government says that it's willing to pursue this one, let us see how it will go. But for me, and from the position of the NPP, we see that these are just, the government itself has begun making excuses for her. And so the will is not there.
When you say excuses, what do you mean?
Some of the excuses are the due processes that they speak to be talking about. These should not be stemming from the government communication. This should be coming from her own private dealings in terms of her ability to appeal and all that. But all these are being cited because they know that that is how it is going to go.
Legal proceeding and government's excuse. Where does it tally? Because you, in one breath, you've mentioned that these same things should be accorded the former finance minister who is going through the entire legal process, and you say that is a defense by the current administration as well for Madam Tamaklo.
Yes. So with that of the former minister, in fact, the government that is pushing for his extradition they are also aware of these procedures. Yet, how do they make it look? even as at the time he was in court, when they were pushing for the extradition, there was no formal document as to that. And so no court was going to extradite him when there is no formal extradition order. How did they expect the court to take such a decision? Yet the government's position is that he should be extradited to come and face charges. Whilst the government is aware of the procedure which should go through and the rights that accord him to be able to also challenge it at all states, even in the US and when he comes to Ghana. So then where is the government making that distinction? Because if you know this, all these processes are available, and so they are available to Sedinam Tamaklo, why not available to the former finance minister?
That's the question being asked, and the extradition request not being present when bail conditions were being considered for the former finance minister. It came off as an indictment of some sort, because that appears to be top on the list for a lot of Ghanaians if you want to compare it to Sedinam Tamaklo, and yet we didn't have extradition processes served on the court which is considering Ken Ofori-Atta's possible deportation to the country.
My brother, you see, the points must be made. My good brother over here appears to be a very decent person. I saw the flyer. He said he is a lawyer, or that was the description at least given to him.
He's a partner. Are you not a partner at a law firm?
He is in fact a partner. And he himself on this show this morning has confirmed that he is a lawyer and a partner at a law firm. And so it beats my mind how he is so disingenuous to the legal conversation we are having on this platform. And because tell me how the legal options that is available to a person who is a subject of a legal proceeding, such an individual whose right it is, or who the laws have afforded in various regards to protect their rights, how does that correlate in any way, shape, or form? Or how does anyone come to the conclusion that if such an individual or that individual takes those steps, it means that the government is protecting such a person? I don't understand. I am finding it very difficult to understand. And it is leading me to question his credentials as a lawyer. Honestly. See, let's be very, hold on. So you see, it is two things. When you decide to play the ostrich, okay, and be politically convenient or politically expedient, you risk your own reputation. So it is either, hold on. The political convenience is the fact that we are saying that according to the laws, even though the courts have pronounced that Sedinam Tamaklo is to be extradited, she has within her rights certain avenues available to her to challenge that pronouncement of the court.
And they say, hold
on. One of such options is for her to enter an appeal. 2, another option is a habeas corpus application challenging the authority of the people who have held her, whether or not they have the legal authority to in fact hold her. 3, the pronouncement of the court is subject to administrative and executive approval. So it is within the bosom of the Secretary of State of the United States of America to determine whether or not she should be extradited. Those are options or avenues available to Sedinam Tamaklo. And so if she decides to protect her rights by exercising those avenues that are available to her, how does any individual in Ghana make the sound judgment and conclusion that if she does so, then it means the government is trying to obfuscate matters and protect her in certain ways?
I think the question
now,
being,
you see,
the question being asked is, why are these solutions, possible solutions as to her defense, coming from government spokespersons? How is and not because you've detailed the manner in which she can have her rights done by her, right?
Yes.
And you're mentioning appeals,
yes,
and the entire processes and all of that.
Yes.
The argument he's making is simple. Why are you not according Ken Ofori-Atta the same sort of argument in terms of him as well using his lawyers in fighting and ensuring that he doesn't return to the jurisdiction. You're making these excuses for Sedinam. And also, why is it coming from you and not coming from persons close to her? It's a question he's asking.
So my difficulty is with the fact that we are terming this as an excuse. How is it an excuse? When I said it by way of information, because we have a duty to the people. So it is not enough to come and sit here and say that the court has made a pronouncement that Sedinam Tamaklo should be extradited. And so I am adding more context that even though the court has made a pronouncement, these are the procedures in the US.
Absolutely.
And so this is by way of information and education, and not necessarily a government excuse or position. I don't know if you understand it, because even though we come to sit here as government spokesperson or people speaking on behalf of the party, we have extra responsibility to educate the people where we have the opportunity to.
Absolutely.
And so when I come and I sit here and I say that she should be extradited, I must also be quick to add that, okay, even though the court has made a pronouncement, it is not definite and automatic, because there are extra procedures that can be exhausted by the individual in question. And there are administrative and executive, powers that would have to agree whether or not, in fact, she should be extradited. So how do we say that this is a government excuse? And then secondly, you are asking me, why are we not according these privileges, all right, to the former finance minister? Is it within the domain of the government of the Republic of Ghana to make a pronouncement or make a decision or a determination that a habeas corpus application should be entered into by Ken Ofori-Atta? If he so wishes to do so, he will do it. If he wants to enter an appeal, if he is found, if a case is found against him and he is extradited, or the court makes a pronouncement, if he so wishes to enter an appeal, he can enter an appeal. If he so wishes to file for a habeas corpus application, he can do so. If the Secretary of State says that he should not be extradited, they can make such a pronouncement. It is not within our remit as the Republic of Ghana or the government of the Republic of Ghana or members of the opposition in Ghana to say that Ken Ofori-Atta, do not come because this is available to you or this is not available to you. How is that? And so I am struggling to see the correlation. How do we say that this legal solutions or avenues that are afforded or accorded to persons or parties to an application in the court of law then metamorphoses to mean that government in the Republic of Ghana is looking for excuses?
Speak to me on the Ken Ofori-Atta bit. Why he as well going through same legal processes then becomes a challenge and you continue to ask.
It is not a challenge for us. But the point we are making is very simple. They have continued to make the point that Ken Ofori-Atta is not guilty. They have continued to make the point that Ken Ofori-Atta has given an honest account of himself in the role as finance minister. And so we are all pursuing accountability as a country. One of the major issues that the Ghanaian people concern themselves with today is accountability and aura. And so there is a consensus around the table saying that let's exact accountability from public actors and officials. And so if you are very confident within yourself that you've given the people of Ghana a good account of yourself in office, just come and render that account to us. That is not too hard to ask. Why are you fighting this? To the point where you ridicule yourself so much so that they hold you in detention facilities in the US. Just come to Ghana, sleep in your own bed, and have your day in court. It is not a case that when you come to Ghana, immediately you are going to be pronounced as guilty and then sentenced to a prison term. No, it is not the case. You would have your freedom afforded by the Constitution of the Republic of Ghana to make your case. And where you are found to not have engaged in any criminality, the court will clear and acquit you, as it was done in the case of former Deputy Finance Minister Ato Forson. So how is that any difficulty? And I was listening to him saying that when we came to office, immediately we entered an oral prosecutor for Ato Forson. Christ Lord, are you in this country? A court of competent jurisdiction cleared and acquitted him. He was cleared of all charges. Are you not in this country? And so how is it the case that it was the NDC that came to office to clear him? It is not the case. He was cleared by the court itself. Mm-hmm. He did not flee the shores of Ghana. He stayed in this country and answered the questions. in court, and he was cleared. And so, under the MPP, we knew how you were pursuing accountability. We knew how you were pursuing former government appointees. And so if he could stay and answer questions in court and be acquitted and cleared by the court, and today he's serving as finance minister, what is so different that Ken Ofori-Atta cannot be subjected to the same rigorousness of the law? Why is he running away?
Bernard.
Right, so let me just respond to what my brother is saying. First of all, Ken is not guilty because he has not been proven guilty by any competent court. Let's get that right.
Nobody say he's guilty.
Yes. And so whatever accountability is there to be rendered would be. But the same reason that took Sedinam Tamaklo out of the jurisdiction is the same reason that is keeping Ken out of the jurisdiction. And that is on medical grounds. But does it not surprise us that the NDC seems to speak and educate the public on the availability or the remedies that are available to, Sedinam Tamaklo? Yet when it comes to that of Ken Ofori-Atta, that education that should go to Ghanaians is not there. We are saying that the will is not there. And he mentioned of the case. We know the case of Dr. Stephen Okuni. We know the case. We know the case of Dr. Johnson Esiama. We know the case of Samuel Ofosu-Ampofo. All these are cases which shows that the political will is not there. And so if the NDC is saying that this time they want to go through with it, we are hoping to see that. But they shouldn't, on one breath, be trying to educate the public by giving the public information on what are the steps which are available for her, which will invariably delay the whole process. That shows that the will is not there. And so the same thing can be done for Ken Ofori-Atta, to also educate the public, to let them know that these are the rights which are also available to Ken Ofori-Atta if it is by way of education. Then let the public know, so that if that process is not happening, it is not that he is invading or he's not trying to be accountable, but he's also exhausting all the legal remedies which are available to him. And that is the point we are making.
You see, I have said that my brother over here this morning stand the risk of running down his own reputation as a lawyer, a partner at that.
But the
when
point
he continues,
he makes is valid,
when he continues to engage in this deliberate dishonesty and obfuscation of the facts of the matter, that must be made. And so if he continues on this politically convenient tangent, then he runs the risk of running down his own reputation. Because why are we comparing apples and mangoes? In the case of Ken Ofori-Atta, no pronouncement has been made. The substantive matter is still before the court. And so why should we even jump to the conclusion to come and say that these are the avenues or the remedial avenues that are available to him when the substantive matter has not been dealt with? The substantive matter is still before the court. It can so come that the court will make a pronouncement that there is no matter for Ken Ofori-Atta to come and answer in Ghana, and for this reason, extradition would not be done, or there will be no pronouncement in respect of the extradition request that we have made. In that case, what happens? So, why do you seek to jump ahead of the gun and draw these kinds of unfounded comparisons? In the case of Sedinam Tamaklo, there is a definite pronouncement by the court. There is a clear, definite pronouncement by the court that Sedinam Tamaklo, you have a case to answer. In fact, you have been convicted and have been sentenced, and there is a case against you. It is not politically motivated, and so come back to Ghana and come and serve your jail time. But before she is able to do that, there are remedial measures that are available to her within the law, which I have rightly pointed out to. One of such measures is for her to enter an appeal, a habeas corpus application, and in fact, the pronouncement of the law is subject to administrative and executive approval from the Secretary of State of the United States of America. And so how are you comparing a matter that has come to its logical conclusion, fully exhausted, to a matter that is still before the court, a substantive matter that is still before the court? Without the exhaustion of the substantive matter, there is no way remedial measures will be available to the finance minister, the former finance minister. And so what is the need for that argument at this point?
I didn't hear you speak to why the extradition process we put in was not available to the judge when he was considering bail for Mr. Ofori-Atta. In fact, it was one of the many reasons why he was let out of detention, because he says the extradition process which Ghana has filed, for which reason there's an argument that he's a flight risk. There was no documents before him. Where are the extradition processes for the former finance minister, and why is it not before the judge who is currently hearing his breach of his stay in the US?
Well, the fact of the matter is that the fact that he has been granted bail does not mean that he has been cleared or the extradition.
Absolutely, but
let me just make the point.
Right.
Or that the extradition processes has been truncated. It is not the case. If the pronouncement has been made that there is not enough evidence or facts before the court, it only means that the attorneys or the lawyers who are in pursuit of this extradition have more work to do to submit. And in fact, we are in a spirited pursuit of this extradition, and I'm fully aware that new cases have been submitted, facts and evidence have been provided. In fact, there was an issue between the office of the special prosecutor and the attorney general, because when you are acting for and on behalf of the state, it is the attorney general that does that. But the original case of extradition was started or instituted by the OSP. And so I'm sure there had been some discrepancies. All of those have been corrected, and they are now in synchrony, and the extradition is in full force. We are pursuing it, and we are going to make sure that Ken Oforiatta comes back to the Republic of Ghana and renders an account of his office to the people of Ghana. That is not too much to ask. We have given you an entire coffers to manage the country's coffers. And we are asking that at the end of your tenure, how did you manage my resources? Just give me an account. And you want to evade the laws. You want to evade the people who have given you that power. And these are the very same people who want us to give them the opportunity in 2028 to come back and lose this country all the more, if they are so much averse to accountability.
So where are we on the extradition? Do we know?
Well, for what I can say is that they are still dealing with a substantive matter, and so the matter is still being argued in court. I don't know whether or not a new date has been set for subsequent argument as of yet. But what I can fully tell you, what I can assure you and assure our listeners, is that we are in a spirited pursuit of this extradition request, and we are going to make sure that it goes to its full, exhaustive conclusion.
Right then. Maybe final word to you on that, and then we'll switch lanes to a different topic.
All right. So my point is that if documents, the basic documents that should be served on him for the extradition process to even begin has not been served, how do we sit and compare that to Sedinam Tamaklo, who has been convicted and in fact her extradition order had been granted? It's the two is nothing. We are only vilifying the former minister. Why do we even have to compare the two processes? Because it's not the same. So that is the point.
Right. 2 minutes to the top of the hour here on the 3FM Sunrise. I'm in studio with Raymond Tamaklo and Bernard Kwesi Kwafo Esquire. We're having conversations in relation to the extradition of former Maslok CEO Sedinam Tamaklo, who we understand the judge has okayed for her extradition, but like we know of, there will be processes and will have to be approved by the Secretary of State. We're going to switch lanes right now and get into some other matters, but we'll do that after this break, and then we talk anti-LGBTQ plus bill. Is the NDC changing its narrative on a law they so vehemently promised to pass? We'll get into that after this. Stay with us.
Protect yourself from germs and bacteria.
An alternating position by the government, right? I'm going to have us listen to the president speak to the matters of LGBT, perhaps in opposition and then now, and then the minority as well, who've been addressing a news conference and asking questions. And it's come up quite strongly again for conversation in the last few days as to whether or not the NDC use LGBT as a yardstick to influence voter outcome, and after which abandon it. Here's the president speaking very recently as to whether or not LGBT is a subject matter of interest and priority for us Ghanaians, and here's the president in his own words.
The issue of LGBTQ rights are emotive, and they are not completely settled in terms of their nuances and arguments, not only in Ghana but all over the world. Even in the United States, you still have discourse on LGBTQ rights. There are still 26 states in America that have legislation that restricts LGBTQ rights. And so for a country like Ghana, our democracy is playing out in respect to what those rights are. And let me point out that the bill in Parliament is not a government bill. It's not a government-sponsored bill. It's a private member's bill. And so Parliament owns that bill for now. And what the eventual nature of the bill would be, nobody can second-guess Parliament. And I, as President, cannot anticipate, Parliament in respect of that bill. But I believe that our democracy will work out. Memoranda are being accepted from all people of all walks of life. Civil society organizations are all presenting papers to Parliament. And I believe that our representatives, the representatives of the people, will make the will of Ghanaians reflect in whatever bill eventually comes out. And so I swore an oath to uphold the Constitution. And so the representatives of the people will discuss the bill, and once they pass it, then it comes up to the presidency. And the Constitution gives various pathways for dealing with it. If I object to the bill, I can send it back to the Parliament. If there are issues that need to be dealt with, we have the Council of State, which is a superior body. I can refer to the Council of State for advice. And so there are many issues that are still playing out. But I believe that our international partners should understand that public policy is grounded in our legal traditions, in our cultural context, and in our social consensus. And all those issues are playing out as we speak.
Some other stories.
There's been... So that's the president then. I want us to hear from him in opposition now in relation to these same matters.
Empowerment in our society. My fathers and mothers in Christ. The current legal impasse created by the Akufo-Addo Bawumia administration on the Promotion of Proper Human Sexual Rights and Ghanaian Family Values Act, which was passed by Parliament, has set a dangerous precedence for our governance. The constitutional directives for action by the President are quite clear and need not have resulted in this stalemate. As I have publicly stated, I'm a proud member of the Assemblies of God Church, and my faith does not permit same-sex marriages or relationships. No. Thank you. My faith does not permit same-sex marriages or relationship, nor does it endorse human-animal relationships, or does it allow people to change their gender as they wish. This is a fundamental belief that I hold and is grounded in my faith. I therefore assure you that the promotion of LGBTQ and all the pluses will have no place in our schools and communities under my administration. Thank you. Thank you. Thank you. In addition to the above, the next NDC Mahama administration will undertake sound policies and programs that will ameliorate the suffering of our people, reset our economy.
So that's the president in opposition as well. I'll start with Raymond on this one. The narrative has changed. In fact, I wanted us to listen to the president again speak to the same subject matter and say that it is not a priority. Matters on LGBT is not a priority for the Ghanaian, and as such, we should go easy on all of the demands and all of that, and that the focus is on jobs and creating jobs and whatever. Let's listen to that first as well, and then I return.
First Council, LGBTQ plus issues. It remains a highly emotive and sensitive issue, even in the most advanced liberal democracies. I explained during my recent engagement with the World Affairs Council that it's not the most important issue we face as a nation. We're still grappling with the provisions of basic needs of education, healthcare, jobs, food, clothing, and shelter. Nevertheless, the private members' bill introduced in Parliament has sparked a complex and sensitive national conversation. Our position is guided by our Constitution, respect for human rights and dignity of all persons, and the need to preserve social cohesion. While there are strong and differing views within our society, we believe that these issues must be addressed through democratic processes, our core values, dialogue, and the rule of law. I'm also mindful of reactions from our international partners, including the recent developments such as Lincoln University's withdrawal of their honorary doctorate. These developments underscore the importance of continued engagement and mutual respect, and of situating our national decisions within our constitutional and cultural contexts. Ghana will continue to uphold its democratic values while engaging constructively with the LGBTQ plus issue.
So that's the president. Why is it not a matter of importance or a priority to us now as compared to comments made during opposition?
And so, from all the videos you have played, I have watched very keenly and carefully.
Right.
I do not seem, or I am at sea, or at a loss with what the thrust of the matter is over here. There is no issue over here. The only people who are trying to make an issue out of this matter, where there is in fact no issue to be made out of, is the NPP. And we are not going to cower to them. And I would want to reiterate the position of the president that matters of LGBTI are not the most important to the Ghanaian people. And that is the facts of the matter. But the case must also be made that if the president said that issues of LGBTI are not the most important matter to the Ghanaian people, does not conclusively mean that they are not important. This is purely grammar and common sense. When we say that this is not the most important matter to me, it is not to say that this matter in and of itself is entirely not important. That point must be made. But if you call the average Ghanaian today and you ask them what their major concerns or what is on top of their minds this morning, they will tell you issues of jobs, cost of living, health, education, the cost of fuel at the pump. These are the topmost priorities to the ordinary Ghanaian person. How to be able to afford a 3-square meal. This is the most important issue that continually the ordinary Ghanaian person is confronted with. And so it is a fact to say that LGBTI matters are not the most important, but does not mean that they are not important. And the case must also be made that it is becoming increasingly annoying that the Westerners at all times would want us to have conversations about LGBTI when Africa and its people are confronted with germane issues. Our development partners must know that we seek development, how to better improve the living conditions of our citizens and of our people. And so if they have any help to render, then it must be in line and within the spheres of education, how to help us ameliorate cost of living, health, and all those matters that are the primary concerns of our collective people.
Were all these not present? Let me ask the question. Were all these not present, these germane issues you speak of? At the time, it's been agreed around the table that we went through the most difficult time in the dying embers of the NPP administration, economic challenges and what have you. And yet, the NDC gave the former president and the NPP no room to sleep in demanding passage of this bill. Suddenly you're in office and you remember that there are germane issues and so you want to consider that first before the matters which you were raising and for which there was a protest about at some point in time.
So you see, if you had allowed me to land, then you'd have appreciated the full complement of the context I wanted to provide to the conversation. And so that part, I am only seeking to offer clarification.
Right.
When the president says that it is not the most important issue, that is because it is important. But to the average Ghanaians, there are more prevailing matters that are a concern to them. And this is what we seek collaboration with our development partners for. It is on matters of LGBTI. Secondly, the president has brought this matter to a definite conclusion. He has said categorically and boldly that should this bill be brought before his office, he would readily assent to the bill. Has the president not said that? That should put the matter to bed. The Speaker of Parliament has declared publicly that the president has assured him that if this bill is passed into law by Parliament, he would readily provide an assent. So that must bring the matter to a conclusion. President Akufo-Addo, when he had the opportunity, could not even make a definite pronouncement on whether or not he would assent to such a bill. In fact, we saw what he did. And even a precursor to what he did in the dying embers of his administration. In 2017, when he had the opportunity to speak at Al Jazeera, he said that if there is action enough, demands enough, then LGBTI is bound to happen in Ghana. That is what President Akufo-Addo said. When the matters of listen. When the matters of LGBTI were raging, the bill was before Parliament. Finance Minister advised the president and the government at the time that should we pass such a law, we would be losing to the tunes of several millions of US dollars if Ghana should pass such an LGBTI bill. And so for them in government at the time, it was more about how we can get from these people and not passing the law not passing the bill into a law. If the NPP had assented to this law, they would not have been having this conversation at this point. And so what is the issue they want to introduce over here? The president has been definite, categorical, and very plain and blunt that if the bill comes to his desk at the presidency, he would assent to it. We all know how bills become law in this country. He is a lawyer. You read Article 106 of the 1992 Constitution, and it spells how bills becomes laws. Gazetting, introduction, first reading, second reading, committee stage, consideration, third reading, and then it becomes a law. And then it goes to the president for assent. Then it becomes a law. We are still at the parliamentary legislative state, and we are crying foul. There is no bill before the president. He has said that if it comes, he would sign it. Parliament is still within the processes to make sure that we sign the law. Today, we are committing resources to making sure that this bill becomes law when all of these processes had been undergone under the NPP.
Right.
And they refused to sign. On 4th March of 2024, President Akufo-Addo declared that there is a matter before the court. And so no bill should be brought to his desk until that matter is resolved. When in fact, the matter that went to court went on 5th March. And so you could see that they collaborated with person to go to court so that they can hide under the banners of law or of the court to not assent to the bill because they want millions of dollars from the Westerners. And so we know who has the political will. In fact, you saw the statement that Asante Bediotu wrote to the Clerk of Parliament, giving them a warning: cease and desist from bringing any law to the presidency for assent. I am speaking about the anti-LGBTI law. And so how do these individuals turn around to come and sit here and tell us what to do when it comes to this bill, when it is already clear it is not a matter subject to debate, that the president has the will and has said clearly that if all the outlines of Article 106 of the 1992 Constitution is fully exhausted and it comes to his desk, he is going to give an assent, then what is the issue over here? And why are we wasting time this morning?
Let me come to you as well, Bernard.
Right. So the issue of the LGBTQ was in its height maybe somewhere in 2021 when the whole process of the bill began. In fact, the MPP has never been against the bill. In fact, the MPP stated that there are certain considerations that should have been done and there should have been a thorough debate on the bill. Our president then, Nana Addo Akufo-Addo, who was a human rights lawyer, did also indicate his position that there were provisions or certain provisions within the bill which needed to be looked at. However, all this process was pushed through by the private member bill. And in fact, the position of the NDC at that time, the NDC took advantage of that bill and campaigned, disregarding whatever the government had stated in terms of its implication on human rights. The bill was also challenged in court, and that was why the president could not assent to it. Now, having come into power, and now having had the opportunity to be in government, we were expecting that you would treat this bill with priority. Right now, the NDC is saying that the bill is not a priority. It's not a priority because there are other things like issues that had to be dealt with in terms of our hardship we are going through as a country. What didn't the ex-MPP government go through? Issues of COVID. Russia-Ukraine war, the impact it had on our economies. All these things were issues that the MPP was going through. But yet the NDC saw the LGBTQ bill as a priority then. Speaking at the Kaswa Traditional, forum, which was with stakeholders, which was organized, Alban Bagbin said that we should disregard what the NDC, some people in the NDC are saying that is not a priority because to them it is a priority. This is a statement which is made and is on record. So I don't understand the point in my brother saying that it is not a priority. In fact, the Speaker of Parliament has stated that it is a priority and we are waiting to see. But you see, just before this bill was reintroduced, the President of the Republic stated that he would prefer that the bill is a government bill and not a private member bill. So already things have been put in motion to try and delay the whole process of this bill. Thankfully, that bill has been laid before Parliament, and we are hoping that it should come to the period where there will be an assent by the President. But if we were able to pass the Gold Board bill within 90 days of us coming into power and having based on LGBT to campaign, what prevents this bill from being passed such that now it has to go through all this process because it's not being treated as a priority? And that is what we are saying. The tone of the president speaking in opposition and stating his position, and now his tone speaking whilst being the president of this country is totally different. And that is where we have a problem with that. If you use the same energy that when you were in opposition and you campaign using LGBTQ, then we expect that that bill should have been passed by now. You should treat it as the priority you accorded to it when you were in opposition and not be in government and now change your tone and now trying to cite excuses. As of now I speak to you, there have been certain concerns which have been raised against the bill. And we know all those things are deliberate.
Which concerns?
Yes, some, I think some of the concerns are that there are certain components which would affect, human rights, and all those things must be looked at. It must be looked at based on law. Meanwhile, all these concerns existed.
Are these not concerns that existed that they are realizing and they are agreeing with you on?
Absolutely. These are concerns that the MPP had raised with the bill, but the opposition then never saw anything good with those things that they were raising, but suddenly they are in power and they can now see all these things against the bill. And so all these things are intended to slow down the passage process of the bill. And we can say emphatically that they are not treating the bill with the priority that it deserves.
You said if you pass the bill, we wouldn't be having a conversation now. Had you and the NPP passed the bill?
The bill was passed by Parliament.
I mean, so the
yes, the bill was passed, but it was not assented because the matter was before the court. And once the matter is before the court, we have to pause for the court to determine those issues. And that did not happen before the expiration of the 9th Parliament of the 4th Republic. And so, the 8th Parliament of the 4th Republic. Yes, the 8th Parliament. And so, it falls on the 9th Parliament to enact it for presidential assent. And that is what we are waiting for them to do.
I wanna listen into that Bagbin comment and see the context in which it provides in relation to this particular subject matter. And so here's the speaker, Alban Bagbin, on LGBT.
So a number of members of parliament who believe in it decided to promote it in parliament. And you know the things I said before. I'm not a man of words. I'm a man of action. And that is how we got it passed in Parliament. But for some reason, the president did not assent to it. That one is his own mangana, not me. I'm sure one of the reasons why you punished him and his party is one of this one. So we started and we processed it. It has gone through all the stages, and the next meeting of Parliament will hear us asking to pass that bill into law. So don't listen to people who don't know what is in Parliament. Please, I repeat, don't listen to people who don't know what is in Parliament. His Excellency the President assured me that when we pass the bill and it comes to him, he has stated it before, he was going to assent it. So please, leave the rumor mongers. They can play that kind of calumny, bad politics. That is not what we are here for. We are different from those practicing it. Our cultures and values and principles are different. They know the effect and what it is doing to them. We resist it today. We will not be colonized again.
That's a speaker on that score. That's a sound you were making reference to.
That is so. Yes.
And,
so
and you say it backs your argument?
Yes, it backs my argument in the sense that the speaker stated that we should disregard the fact that they are not attaching priority to it.
He didn't say that. When in the video did he say that?
Play it to the end.
Let me find the full video because this is just 2 minutes. Right?
The speaker has been categorical.
This is just 2 minutes. I need to find the full thing and see if it provides a bit more.
He says
more
that we should disregard people who are playing bad politics with it. That is what he has said.
That's pretty much the entire thing.
Exactly, that's the entire thing. So what did he say? The NDC says it is not a priority. He says that we should disregard people who are playing bad politics with it. And this is what the MPP is doing. The speaker has said that he has spoken to the President of the Republic of Ghana, His Excellency President John Dramani Mahama, and he has given him his word that should the bill be passed into law, he would gladly give his assent to the bill. This is what the president has said. What did President Akufo-Addo do? What did the MPP do? Are you looking for the...
Yeah, I mean, I'm listening to you. Yes. as you make your submission.
What did the MPP do? You see, we must set the issues into proper context. And the context is that President John Dramani Mahama, as executive head of state, says that LGBTI, speaking or addressing the Westerners, says that LGBTI matters are not the most important. As executive head of state, it does not necessarily mean that LGBTI matters are not important in its entirety. Now, the LGBTI matters are now within the domains and within the remits of the legislature. And so while it is within the domains and remits of the legislature, the executive must concern itself with the most germane issues confronting the ordinary Ghanaian person. When the ordinary Ghanaian person wakes up in the morning, he is thinking about how to afford a 3-square meal. When the ordinary Ghanaian person wakes up in the morning, he is thinking about the cost of transportation and the cost of fuel at the pump. When the Ghanaian person wakes up in the morning, the ordinary Ghanaian person is thinking about the cost of living. When the ordinary person wakes up in the morning, the ordinary person is thinking about what? Unemployment, job creation, health, education. And so is it the case that the executive arm of government must be tiptoeing and wait for the finalization of the bill within Parliament before it takes other further actions with the broader issues of the economy and the matters that are concerning the Ghanaian people? What kind of dishonesty and disingenuity is this? Like I've already pointed to you, Article 106 of the 1992 Constitution is very clear that it sets out or outlines the processes through which a bill must go for it to become law. Gazetting, introduction, first reading, second reading, committee stage, consideration stage, third reading, and then it is passed by Parliament before it comes to the presidency. Is it the case? Is the MPP and its minions and assigns and appendages wanting us, or do they want us to believe that the argument they are making is that the executive arm of government must tiptoe, all things must come to a stop for all of these processes of Article 106 to be exhausted, the bill assented into law before the executive arm of government addresses issues of job creation, unemployment, cost of living, fuel prices at the pump? What kind of ludicrous argument are we making over here? What kind of ludicrous argument are we making and wasting our collective time as a people? Let's go on to matters that are of importance. The president has said it. The Speaker of Parliament has said it, that once the bill is passed into law, it will be assented to. Like I've questioned them, and you have also questioned him. When they had opportunity, what do they do? Even a level 100 constitutional law student knows that you cannot challenge the constitutional validity of a bill until it becomes law. Who doesn't know this? And you cannot perverse into the terrain and the remits of Parliament. You cannot stop Parliament from functioning. You can't do that. You don't have that right to do that. But even when President Akufo-Addo, who is a legal luminary, who is a competent lawyer, he knows that you and the outcome of the cases showed. The court declared that until the bill is passed into law, you cannot challenge the constitutional validity of such a piece or bill. You can't do that. Then he goes on to say that there are some human rights issues that the president were concerned over. In fact, you had majority in Parliament. Why were those matters not refined before it was assented to? You were sat in Parliament when the bill was passed into law. Your majority sat in Parliament and the bill was passed into law. You were concerned about the monies you are going to get from your foreign donors. That is why you didn't want to sign the bill. If you had signed it, this matter will not be an issue today. Right. It is within Parliament. When Parliament is done, the president will assent. So they should stop wasting our time.
Bernard.
You see, the MPP has never been against the bill. In fact, the bill was passed during the time we were in government. Our position is clear on this matter. The reasons being cited that it is not a priority, jobs and other things, all these issues existed during the time the MPP was in power. All these issues existed. But it was the NDC that weaponized LGBTQ. And even if you listen to what Abang Bagmin just said, the audio you played, he said it was because of that the MPP was punished by voters. And so they had weaponized it as a campaign message, right, that once they come into power, they were going to pass that. And that is why we are expecting that by that same means, that should be passed. Even this private member bill, which has been established, the NDC had not done in it
Did you
because
listen to the
the private member bill was brought back. The government said they would have preferred that it had come from the government. So if you were willing to pass this bill and to let it come from the government, why wait all this while since you had been voted into power? Meanwhile, there are certain bills that you had passed, and that shows your priority on where your interest is or what is most important to you. But from what you told Ghanaians when you were campaigning and how you weaponized LGBTQ against the MPP, then this bill should have been already passed by now.
Bro, see,
Well,
honestly,
you weaponized
you
it.
see, the truth of the matter is that
the truth of the matter is that it was weaponized at some point. There were protests which were undertaken, and the government said they would have preferred that came from them. It hasn't come from the government. And in the course of the entirety of last year and any part of this year, the minority has been raising concerns that why is the bill not being tabled before the House to be considered? It's a question that has been asked as well.
you see, it is becoming increasingly insufferable listening to my brother over here. Because this deliberate obfuscation and politically convenient argument is becoming very difficult for me to listen to. And I am sure the discerning viewers and listeners who have joined in the conversation will draw similar conclusions or inferences, if I must say. But the point is very clear. Now, what you have just asked me, the NPP, they had 8 years in power. Is that not the case? They had solid 8 years in power.
But it became a topical issue in the last 3 years.
Hold on. The bill was passed by Parliament in 2024. The last year of exiting government, they had 8 years. You are saying that they became a topical issue for 3 years. Why did they not pass it in the first year? I've told you, the advisory from the finance ministry was that if they passed it, they were going to be losing millions of dollars from their foreign donors.
Is that the same advisory you're working with?
Hold on. They were going to lose several millions of dollars from their international donors, and so for this reason, they would not pass it. So they hid under the cloak of a matter being at the court, the Supreme Court, for which reason they would not sign it. One would ask that even if indeed it was the case that the matter was before the court, at the time they were declaring, or the president was declaring that the matter was before the court, was it not a similar situation we faced with e-levy when it was challenged at the court? It was still in the courts when the president assented his signature to the e-levy, because it was chop, it was money, so that they can line their pockets and their underbeds. He quickly signed it, even when it was before Parliament, when the bill was challenged in Parliament, or the levy was challenged in Parliament. So you can see clearly that these people do not have the will to do what the Ghanaian people want them to do. Now, we have come. The matter is before Parliament. I have told you that the laws or the processes have been outlined in Article 106. The Speaker has said that in the next sitting of Parliament, it will be reaching its final stages. And he has spoken to the President, and the President has assured this is only in 1 year and 4 months. And the Speaker has come out to say that the bill has reached its final stages. You played the voice of the Speaker. We all heard it. The listeners listened to it. The Speaker has said that in the next sitting, the bill has reached its final consideration stages, and the President is ready to assent his mandate, his signature to the bill. And so where is the argument? Where is the needless, preposterous, and ludicrous assertion that the NDC is playing mind games with the people and that it is not a matter of priority to us? What we are doing is to set a clear distinction between the legislature and the executive arm of government. Where a matter is before the legislature, it does not mean that the executive arm of government must come to a halt. Issues must be addressed for and on behalf of the Ghanaian people. Issues about job, issues about education, issues about cost of living, issues about the cost of fuel prices. And this is what we are doing. And so if the processes has been fully exhausted by the legislature and it comes within the periphery, the domain and remit of the president, as the executive authority of this republic, he stands ready to assent to this bill to become law. It is very clear. And so what they are advancing is a politically convenient argument to hoodwink the Ghanaian people. Right. And we all can see through the charade. These people who lack any moral authority today, all of a sudden have summoned some temerity to come and sit here to obfuscate matters. When you had the opportunity, ask him, what did they do? We all know, like I've already told you, at level 100,
that point has been
hold on, let me just buttress this point. He is a lawyer, a partner, you have said. A level 100 constitutional law student knows that you cannot challenge the constitutional validity of a bill until it becomes law. But that is what they did. Today, the lawyer that he is able to come and sit here and advance this argument because of his political party. It does not look well on him.
That point has been well made. I'll give you the last word on this, Bernard. And then we get into fuel conversation, because you've been mentioning that is priority. We'll talk about that priority shortly. Bernard, last word on this and what your expectations will be going forward. It says the next session of Parliament, or when they reconvene, this becomes priority. Does that satisfy you in the NPP?
You see, my brother has sat here and professed knowledge of, the processes of Parliament in the passage of laws. Indeed, he has also stated that the ex-MPP government was looking at the financial implications and all that it was going to have on the government, which is valid, because there is no bill which has no financial implication, or there is no law which has no financial implication. And so the government then was right to look at all the implication that the passage of such a bill was going to have on this nation. But what we are saying is that you have weaponized LGBTQ. You have campaigned with LGBTQ when you were in opposition. And so we expect you to attach priority to it whilst you are in government. Right now, we have a private member bill, but the executive has stated that they want it as, they would have preferred it as a governmental bill, or a bill coming from the government. Where is going to be the executive strength in pushing that bill through? Where is the executive going to support that private member bill? Because by saying that you prefer that it should be a governmental bill, you have decided that the executive is not going to be fully involved. It has to be the private member bill that will go through. So we are saying that all these excuses which are being made, or all these statements which are being made, are further meant to derail or defeat the whole purpose. And so I would not be surprised that the passage of this bill is going to be dragged. But if they are saying by the next sitting of Parliament, this passage, there's going to be a passage, we wait to see that. And we are also here to comment on it.
Absolutely. We will be here to follow the process as well. You're still live here on 3FM Sunrise. 80 minutes to the top of the hour. We get into fuel right now.
The big conversation on 3FM Sunrise. The big conversation on 3FM Sunrise.
A number of you have been sharing your thoughts with us as well this morning. I will get into all of it for you pretty shortly as well. But let's talk fuel, because priority. Raymond says that is priority, and that is what government should be focusing on. Some of the taxes are to be removed from the price build-up. Is there a sense as to what taxes is expected now? We know when the Minister for Government Communications announced this, there weren't any specific mentions. The second pricing window is on Thursday. Today is Monday. What do we know?
Yes, and so thank you very much. And so Ghanaians are well versed when it comes especially to conversations about the fuel prices, in light of the fact that the US-Israel-Iran war is still raging. It is unfortunate that the peace talks that were held convened in the Pakistan to see how best to bring this war to an end. Those peace talks have fallen on rocks, and so we are still uncertain about when this war will come to an end. But we are praying. But as a proactive government, urgent cabinet meeting had been held, and decision was taken that some taxes and margins that is imposed on the composition of fuel prices be suspended for a period of time, so that it brings some cushion to the Ghanaian people. That is a sign of a proactive government. That is a sign of a government that thinks fundamentally about the interest and common good of the ordinary Ghanaian person. You have asked if we know what taxes exactly or margins would be repealed, not exactly repealed, but suspended within the period. The indication is that the minister in charge of energy would, between today, tomorrow, or Wednesday, come out with a press statement or address the press and the generality of the Ghanaian people to announce the margins and the taxes that are going to be suspended, so that we continue to ameliorate the plight of the ordinary Ghanaian people, make sure that we soften the hardship that this war is imposing worldwide. And so that is the indication from government as of yet.
That's the indication from government. We're mindful as well as to what revenue loopholes possibly this creates. And this morning we've been having conversations and working the math. 500 million cedis, if that one cedi levy alone goes, that could create problems, will it not?
Yeah, well, it creates problems. But a point must also be made that when there were windfalls, we made sure to save, or we made sure that we saved some resources, so that when the headwinds come, as they are coming now, we can, cushion the people. And so it is not always about introducing taxes to serve purposes, but it is also about making sure that you have reserves, that when push comes to shove, when there are headwinds, when there are hardships and conditions are torrid, you have buffers to be able to absorb the shock and cushion your people. And so even though that indeed it is a fact that it is going to create some 500 million shortfalls if we were to take just the fuel levy away, it is in the right direction to make sure that we cushion the people. Because when things are well, they're the same people who pay the taxes. They're the same people who bear or bore the responsibility of paying taxes, so that government is able to run, so that government is able to implement its policies for and on behalf of the ordinary taxpayer. And so within the period, I don't think that it is too much of an issue that we are going to be experiencing some shortfalls of 500 million Ghana cedis if we take just the fuel levy out of the price composition. It is good so that we are able to cushion the Ghanaian people.
Bernard.
Right. So we in the MPP say that, the decision to reduce some components of the fuel price build-up is a step in the right direction. In fact, it is a similar thing we would have done if we were in power. And the reason is that the fuel build-up is made up of three main components, which is the ex-refinery price. It's also made up of the levy and taxes, and then as well as the margins. We have about 8 levies and taxes which are placed on which are part of the fuel price build-up, and about 5 margins which are part of it. Now, when the Minister of Finance came to Parliament, we export crude. Crude was pegged at $76 per barrel. Now, currently, crude is selling beyond $76 per barrel. In fact, it's above $100. And so there has been a margin that we are also gaining from the rise in the prices as a country. As at now we are speaking, the whole of March, we have made about 8 billion Ghana cedis from it. Comparing that to whatever levies that we take off, that 500,000 gap you are speaking about, the government is still making enough to be able to cushion the Ghanaians in that, the ordinary Ghanaian in that aspect. But some of the levies, there is the special petroleum levy, which is about 1 Ghana cedis, which has been placed on it. That levy can be taken away, as well as maybe the oil marketing, the marketing levy, that can also be taken away. But things like bust margin cannot be taken away because of the impact that it has. Because the bust margin, currently bust is undergoing a lot of expansions and all those things. So it will not be prudent to touch those kind of margins. But the 1 cedi that is placed for the special tax and all those things can be dealt away with, at least to relieve the Ghanaian. And we have always wondered why, I mean, in terms of such shortfalls, that should not be the decision which should be taken by the government. And so we are in tune with that. The government should at least go even beyond and reduce it further. Beyond, I mean, just that one cedi, they should reduce it further for the ordinary Ghanaian to benefit, because they are also benefiting in terms of the price hikes in the crude.
Right, gentlemen, just final words on this subject matter. By what percentage would you expect the prices to go down?
So he says that he has always wondered why we have not already taken an action to suspend some levies and margins on the pricing of fuel. I have a very simple question for him, a very friendly question. That when the prices of fuel skyrocketed under the administration, did he not wonder? And why did they not suspend some levies? We know that in some parts during the administration, when you look at a liter of petrol went to 17 cedis, a liter of diesel went to 23 cedis. Why did they not at the time suspend some margins and some fuel levies so that the prices would come down? As of yet, it would be conjecture or speculation to say exactly what taxes or what levies or what margins would be suspended. The Minister of Energy would come and speak to us, and they would have a definite response or know exactly what levies would be taken off. But the points must be made very clearly that, save for this war, we have managed very efficiently and competently the pricing of petroleum products in this country. In January, when we came to office, when we took over the reins of affairs of this country, the prices of petrol at the pump was around 15 cedis. We brought it down to about 10 cedis for a period of about 13 months. And so I am urging the Ghanaian people to bear with us, that the factors that we can control as a government, we have done well to control. A major factor is the exchange rate. Indeed, the cedi appreciated against the dollar by over 40%. We brought it down from
last year.
Yes, we brought it down from 14 cedis down to 10 cedis. It is the reasons why for 13 solid months, prices of petroleum products at the pump were very low. In fact, today, global crude prices have skyrocketed by 60%. At the time of the war, on 26th of January, on the 26th of February 2026, crude per barrel was selling for $104. As we are speaking, was selling for $71. As we are speaking, it is selling at $114 on the international.
102 now.
No, 114. I checked this morning. 140. You can cross check. It is selling for $114.
On trading economics right now. So
no, but at the time I checked, because the peace talks fell, there was a skyrocketing. It skyrocketed from 102 to 114.
That's fair.
I checked.
It's concluding
yes,
remarks.
and so the generality of the Ghanaian populace should bear with us. What we can do to cushion them, we are going to make sure that we do it.
Bernard, last words.
Yes, so I mean, we all know that the prices of petroleum has been deregulated, and so it is not the government that goes into fixing prices or in terms of, I mean, bringing petroleum prices down, and it's determined by the demand, the forces of demand and supply.
Absolutely.
Yes, and so if on the international stage petroleum prices comes down, automatically petroleum prices will come down in Ghana, and that's what we had been facing. It is now that the government is beginning to take a step because of the rise. And even in the rise, the margin that the government will be losing by taking some of the levy off is far less than what the government will be gaining from the increment in terms of our crude. And so it is prudent that the government reduces it and even reduces it further.
Right then, I appreciate you both joining us. Unfortunately, Austin Bracco Powers could not. Bernard Kwesi Ado Kwafo Esquire is the last individual hearing speak. So is Raymond Tamaklo, is a member of the government communications team, speaking to us this morning on a number of matters. We're going to get into birthdays right now.